So, Calder, tell us a little bit about what the difference is between negligence and malpractice.
Yeah, sure. So that's a very good question. And the short answer is there is no difference. But it's a really good question. This is something we see in every single case and every single trial when we're talking to jurors. We ask them this question: what do you think the difference is between negligence and malpractice? Because there's this common misconception that malpractice is something more or this higher level than negligence, and that's just not the case. Uh, you know, there is no distinction under Ohio law between negligence and malpractice. Negligence is the failure to do what a reasonably careful person would do in the same or similar circumstances, and that's the same for malpractice. They're synonyms here in Ohio.
That makes sense. Is the standard of care though different for a medical professional as compared to a layperson?
So it's not. The medical professional is held to the same standard of care that any of us, you and I, are held to in our jobs, which again is what a reasonably careful person would do under the same or similar circumstances. There's no exceptions or higher level of proof for medical professionals as there is for anyone else doing their job. We all need to be reasonably careful and follow the policies and procedures that are put in place, and do what's safe, and be careful in our jobs. And the same is true for medical professionals.
Okay, so just because you're a medical professional doesn't mean you're like again held to a higher level, because everybody should be held to the highest level of standard in terms of making sure that like their employees or the people that they're working with are safe. So if somebody's working in a company that is a manufacturing company, say, and and that with dangerous equipment, you need to be doing your utmost to make sure that your employees are safe in that case. And in a medical situation at a hospital, it's just like your instead of it being your employees, it's your patients, those people. But in both cases, you're held to that high level of standard where you're just trying to make sure that everybody is safe and you're following all of the proper procedures. Okay. So, so talk a little bit about how a medical professional can be held liable for negligence, even if they didn't intend to harm somebody. Obviously, doctors for the most part we hope, are trying to do their best to heal patients and make them better and not make them worse or do them harm. So, what's how can they be held liable for negligence in a case like that?
So again, that's a great question. We talk to jurors in every case, and that's because there is no requirement that for intent that they meant to do it. In law we use the fancy term mens rea. There is no mens rea for negligence. They don't need to. It doesn't need to be that they meant to do this or they intend to do this. It doesn't even need to be that they were reckless in doing this. In fact, if you're reckless, that's worse, and that could be punitive damages and even further damages. Again, the test is just whether they were reasonably careful, whether they meant to do it or not. And in fact, in many of our cases, they did not intend to do it. And of course, no one's out there looking to cause harm to patients or to injure them. And that's not what the question is here.
Can you give me some examples of negligence that could lead to a medical malpractice lawsuit?
Absolutely. And one of the things I caution is, sometimes people are like, well, it's not this specific name or it's not on this list. You hear a lot of stuff about, doing the entirely wrong surgery, and that's certainly obviously negligence, but it could be doing the surgery that you intended, but not being careful during that surgery, or not performing that surgery to the standard of care. Same thing, you'll hear a lot about getting the entirely wrong medication, and that's certainly negligence, but it could be prescribing the correct medication but at the wrong dosage, or with another medication that it counteracts with and causes harm. Or it could be failing to monitor the patient while they're in the hospital or in the nursing home or in the assisted living, or failing to check up on the patient or have them come back in or follow up on testing. These are a lot of the cases we see where doctors just aren't being careful and it's causing harm to the patients.
At what point should a patient or maybe a family member of a patient, start thinking, "Hey, this patient was or my loved one was injured, and I think that something's not right here. This might be a medical malpractice or a negligence, case." How do they go about figuring out whether or not they might have a case?
Yeah, I mean that's whenever you have outcome that's unexpected and you have some harm, you have some injury. This isn't one, you went in to get better and you're getting worse, or you went in for this surgery and you didn't expect this outcome at all. That's when you should consider talking to a law firm, talking to a lawyer, because they're going to have that case, and we're going to have that case reviewed by an expert in the field who's going to look at what happened, look at what was documented, look at what was done, look at what was not done, to see whether or not this care here met the standard of care, or whether this was a breach in the standard of care.
And so how do you then go about, proving that there was negligence in a medical malpractice case?
So there's a lot of different ways that we prove negligence. First of all, for any medical negligence case in Ohio, you're going to have expert testify as to what the standard of care is in the care that happened here. So whether that's a specialty like a cardiologist or an oncologist, or whether that's even just your general practitioner, your primary care physician, you're going to have an expert come in and explain to the jury what the standard of care is, and then look at the care here, review the records, and say whether the care here met that standard of care or didn't and was a breach. But we'll also look at some other good sources for what the standard of care was, to then look at whether or not it was met. For instance, in every case, we get the policies and procedures of that hospital or that facility to look at whether or not they were following the policies and procedures. And if not, why not? We got to figure that out. Was there adequate staffing? Did someone call off that day that was supposed to come in? And in addition to the policies, we'll look at nationally published guidelines. There's the American Medical Association. There's different or professional organizations for each specialty, like the American Heart Association, and they publish guidelines that are for all of their members and practitioners in that specialty to follow. And we'll look at whether or not those are being followed in this case. And those guidelines come from medical literature, from medical studies, where they're looking at clinical studies and finding what works and what doesn't work, and reporting that. And so again, we'll look at the medical literature too in those studies. We'll say, well, we found, according to the science, according to these studies, here's what works. Were you doing that in this case? If so, why not? And so we'll put all those things, present all those to the jury for their decision as to whether or not there was medical negligence.
So you could have a case where the hospital was actually following all of their own internal procedures, but the hospital itself maybe was not up to date with what the latest information was, or didn't have the latest data, but when they should have.
Yes, you will see that, and you'll see that you can see when the policy was last updated. Maybe it hasn't been updated in 5-10 years. Anyway, we'll say who last checked it off, and why haven't they looked at it again recently? Are they aware of these studies since then that say something different than their policy?
And so, what should a person do if they do suspect again that they did have, either for themselves or for a loved one, that there was medical malpractice that happened? What's kind of their first step?
Yeah, I mean, the first step is going to be to both reach out to a law firm and to start looking at their medical records, especially today with MyChart and online access. A lot of times patients can come in with already having some of the records, and that can help expedite the process and get it going. Now, you can't get everything through MyChart, and obviously you're not going to get things like policies and procedures. That's why it's important to talk to a lawyer as soon as possible so you can start collecting all of this.